Item 12. You're for the consent of the petitioner? Okay. Item 12, as per the adjournment slip circulated, matter adjourned for 2 weeks. List on a date after 2 weeks.
Leading counsel is severely ill.
21.
21 and 22.
Next week, 24.
21, 22, adjourned at the request of Mr. Adas. Consent of the MSA guy, you're referring for respondent.
Yes, sir.
It is for the petitioner. What is this matter?
Madam, this is regarding filing school matter. They again filed with petition.
So, when do you want it?
24th, madam.
24th.
My lord, interim
Interim order, if any, will continue till the next date of 24th.
Have to mention item 39. The matter may come up any other day. The microorganism from the river. 39.
Item 39.
The matter may come up any other day.
Item 39 at the request of Taluja. Matter, this is 2014 matter, madam.
Any day also.
Pass forward for the day.
I think over see my lord, where it is 13 measurements. I am on behalf of my respondent.
Where is the petitioner?
It's on my part, our part.
Let it remain. Top of the list. This matter is indicated as the top of the list.
Only for today.
Let the matter be called up. We'll see. 5 and 6 adjourned for 2 weeks. The request of Mr.
Yeah.
For Guwahati University. Yes, madam.
Yes, I'm from the petition side.
No objections from the council for the petitioner. Adjourned for 2 weeks. Will be fixed after 2 weeks. The date will be fixed after 2 weeks. Yes.
Lordship, I will give for mistake motion. Because last year on 26/5.
Admission
Admission. For 28/29.
September 1st.
I mention item number 70.
30.
Very much.
No.
Take the consent of the others.
So partner matter.
On the last occasion, we had taken time for engaging the senior counsel, but the petitioner was unable to engage the senior counsel. So Mr. Anton will come and argue the matter on 29th of August in this month.
All right, 29.
My pleasure, Lordship. Lordship, I beg to mention for listing of a requisition, Lordship, for admission.
1st of September.
Okay.
Maybe you also, but you recommended for listing of 2 matters, Lordship, one exhibition and one contact of the Lordship.
Fresh or old matter? 1st September.
Supplementary list for withdrawal item 43.
As submitted by learned counsel for the petitioner on instructions that the petition has become infractuous. Accordingly, the same is not pressed. Mr. T. Chisti, the counsel for the secondary education does not object. Accordingly, writ petition dismissed on withdrawal. Interim order, if any, stands vacated.
Hearing is on motion item 1.
CD, call for CD. Call for CD.
I have been instructed to.
Oh, all right. At the request of the learned counsel for the petitioner, and so and so, is paid, who submits that the bail petition is not pressed, according to the same is dismissed, is not pressed.
Item number 2.
This one code directed my lord the authority to consider my lord the provincialization benefit of the petitioner. Here my lord the speaking order was part my lord page 46. That my lord the petitioner my lord is senior to his rival my lord. Page 46 my lord, but consequential my lord the provincialization benefit is not given to the petitioner. Page 46 order my lord.
Rules for the respondent, Mr. U. Sharma.
Yes,
What do you say? Last order, you were supposed to obtain instructions.
Yes, madam, but instruction is writing, madam.
Mr. U. Sharma, learned standing counsel, submits instructions as sought for and not been received and are still awaiting. He seeks further time. Mr. A. Borgia, learned counsel, submits that. Let him obtain instructions.
my lord.
Does not object to the prayer made placed after 2 weeks.
Yes.
2 weeks.
My
Supplementary list for motion item 44.
on the last petition, comment is directed to file affidavit. Matter is whether I am eligible for NCL as a non-criminal status. Can I have any right to claim non-criminal status? And therefore, my lord, I have a right to participate against the reservation quota. Fixed for office.
Have you filed the amended post title?
Yes,
Not reflected here. How will it come to you today? You are experienced counsel. You know, yesterday if you filed, how will it get connected to the case reports? Yes, okay, let it come up on Monday. In terms of the earlier order dated 14/8/2023, the learned counsel for the petitioner was directed to file amended post title before the registry. So it is submitted that the amended post title was filed yesterday. Stop registry to verify and make necessary endorsements if required on the basis of the amended post title stated to have been filed by the petition based on Monday.
Issue a direction to district to bring on record.
We have directed them on Monday.
And what you will consider my prayer for implementing on Monday.
You first file it, let us see. You renew your prayer, we're not rejecting your prayer.
I am moving from Pinnacle to post.
You renew your prayer.
Or intention of party item 45.
Here you go.
Item 25.
Huh?
Item number 25.
25. You are seeking implement of you want to be implicated.
Yes, and the respondent number 6 to 14.
Yes, who's appearing for the respondents?
Item number 25, they have to there.
All likely to be called up along with 25.
Yes. Obligement.
For admission, item number 3.
I can't hear you. Be a little louder.
Well, already this 23 to 2023, the finance was included as a party respondent. And probably the copiers were being served to us, when that's why you are unable to have the inspector. Mayor came us after 2 weeks on the meantime. Regarding non-payment of salary to the petitioner, that's why it's being provincialized in the country.
It is submitted by Mr. D. Goyal, Understanding Council Finance, that in terms of the order dated 23 to 2023, the petitioners, the Department of Finance was required to file an affidavit. However, the copies of the writ petition were not furnished by the petitioner. He therefore, have you received a copy now?
Now I have got the police.
Mr. Gogoi submits that he has procured a copy. In the meantime, and therefore he seeks further time of 2 weeks to file the necessary affidavit. MS so and so appearing for the petitioner as does not object, matter be listed after 2 weeks.
Item 4.
Yes,
We are awaiting instructions from the education.
you are not awaiting, they are supposed to furnish it before the court. Yes, Mr. Chaudhary. No affidavit filed.
This matter, awaiting instruction, we will be filing affidavit, 10 days time may be given to us.
Mr. K. Fukan, Understanding Council, prays for further time to file affidavit. Mr. G. Z. Ahmed, Learned Council for the petitioner. Appears for the petition. What is your name? Mr. S. A. Riaz appears for the petition. List after 2 weeks. Let them file the affidavit.
Item number 7.
Yes.
Before launching, appointed a continual mathematics teacher in high school. Telling before launching, under the orders, and then he pays 30 by. Yeah. Pays 30 by.
Is 30,
minor.
yes.
This termination order was issued by the headmaster, member secretary of the Sri Pitambur Dev Goswami High School, minor, Nagaon, minor. And this termination order issued on 12/8/2015. And my lord, during the, I was arrested by the police on day 2015, my lord. And I was behind the bar. Within after 2 days, without including and without according to the opportunity, they terminated me by putting some stick on my
Where is the order?
order by the case 30, Mary.
30.
Yes,
Yes.
Sri T. Sharma, dated 12/8/2015. Termination from the post of protection additional benefit. It is hereby informed you that with reference to the subject cited above and pursuant to the letter of so-and-so issued by Inspector Nagaon, as per decision taken in the earlier meeting of the School Management and Development Committee of Sri Pitambur Dev Goswami High School, held on 11/8/2015, you are relieved and terminated from the service as contextual additional benefit teacher with effect from 1/8/2015. As per terms and conditions number 9 of the agreement of your appointment and till your conduct has put a black spot in the prestige, reputation, and educational environment of this school, and consider the fact of not to cause any future harm in the educational environment of the school. And since the news of your illegal conduct has published in media and you are arrested by the police secretary of health, the school management and development committee has taken this punitive action against you. This is the termination order, my lord. Then FI was lost on 9/8/2015. And that day I was arrested. After 2 days, when I was behind the bar, this termination order was issued. And by putting a stick on myself. This may kindly see before that, my lord. If allowed to permit me, my lord. Please, Alexa B case 24.
So then what happened? You were acquitted.
I was acquitted, but without any opportunity during the judgment matter. If there is a putting in stigma, there must be a. But for possibly must be.
Yeah, what is the stand of the department?
Department might have not filed any affidavit, and the school authority has also not come. And after receiving complaints to the court order, my lord, there is a court order, my lord.
Where is that clause number 9?
Yes, clause number 9, I was stating in my repetition, my lord. My lord.
Where is the agreement?
Yes, agreement, my lord. Agreement, my lord, last decision after hearing the parties and both the parties, honorable court directed me to place the agreement, my lord. But my lord, respondent and school authority has not appeared, and I have not got the entire my lord state of Assam, those contextual appointment was issued, every school. There is a my lord agreement, my lord. I collect it. The agreement minor, all same year, same months minor, all appointment was made in the minor high school minor. This is the one of the issues minor. This is the annexure A, is the issued by the director, and paragraph 9. Paragraph 9, third case, paragraph 9.
You don't have your copy of agreement.
Yes, pilot, I will not, but other, same order, 9 pilot. Notwithstanding anything contact hearing above. The service of the party may be terminated at any time by the SLC. If the party found to be guilty of any insubordination, intermediate or other misconduct or any or non-performance of things, clearly understood that the school term will be involved. My lord, is found to be guilty. I was not found to be guilty at the time within 2 days, my lord. When I was arrested, without any notice, without any suspension, they directly from the service by putting a stigma. My contention is that, my lord.
You're appointed by whom?
On context or appointment by the school management committee, pursuant to the director of the secondary school.
Where is that order?
But that is my lord, please, my lord. Annexure B, my lord. The appointment data, my lord.
This is by the school.
So well, at that moment, if one of the permit, I want a notification. All at that moment, my lord, when all are at that advertisement have been directed to the all school, those who are there in second post. For the small function, there's a minor people in the government to some secondary department. My lord. There are 1 and 2 by the department. Everything is there, and how can I appoint that kind of thing? The schools under secondary education, higher secondary school, high school, high madrasa, time school, high education, suffered due to shortage of teachers during the period of prior 2010. The regular telephone were taken due to interference of the court of law in filling up the vacancy of the same school institution. It was assumed that not filling of schools, basically school subject in regular sanction is responsible for deterioration of the quality of the secondary education of the state. Therefore, with the approval of the cabinet, government in secondary education department resorted scheme to strengthen the improve the quality secondary education in the state of Assam. High qualification state in 2010, under which 3 additional teachers in the core subject English, social studies.
No, this is a policy decision.
Yes, madam.
Pursuant to that, you are appointed. But
All
your appointment is by the school management committee.
Yes, madam. Directed
Your
by
termination is by the school management committee.
initially directed by the school management committee, thereafter title and thereafter all are regularized after the time and expect.
Where is that regularization order?
Days. My typo is 59. Days 59. To all inspector of schools, subject government notification in the matter providing equivalent benefit to regular pay scale and corresponding studies that is working. Additional teacher engaged on contextual basis in different higher secondary school and high school. Government notification number 17/2010. Inviting reference to the subject, I have the honor to inform that government of Assam is pleased to issue notification and reference method, providing equivalent benefit of regular pay scale and corresponding service benefit to working additional teacher engaged on contextual basis in different high secondary school and high school, high madrasa under the skill, strengthening the improvement quality.
This is to offer you the equivalent pay scale.
My
Kindly come to page 51, second para.
Yes, madam.
The agreement is to be made between.
Madam, what agreement was time to time, they are for all additional teacher, not only my.
I agree, but your appointment was by the SMC, termination by the SMC.
But that is the on the approval of the government, madam.
Maybe, but unless you say that you are able to make out a case, we don't see how you can issue a writ.
Because of that matter, I was appointed due to court of law, the director of higher education, secondary education directed to the all schools.
Directed to the schools to appoint.
Yes, ma'am.
That does not mean the government has appointed.
No matter.
There has to be some order or whim from the government where some control is there by the government. On your services.
Interference of the court and due to file a vacancy, the director has secondary school directed all school, not only me, madam, more and more.
Directed. Why I do not realize it, the direction is all right. The direction is to fill up the post, but the agreements are to be executed between the petitioner and the school.
And
Government, it is not a tripartite agreement. It is not an agreement with, let us say, an agency of the government like the SSA or.
school of this school is the under the secondary department.
But it is not with the officer of the department. It is with the school management.
I
Committee.
was appointed and other schools were.
Who pays your salary?
But government file.
Where you say that? Who pays your salary?
Government file. My notice with office and I done para 3 page, para 3 and second mile. Para 3 minus 2 minus for the pizza over not is qualified and second school should identify against pizza and they will be against temporary against second school. Prevailing the condition fees pay of 1500 per month, 500 per month. Joining against the earmark and maximum period of 5 years. During the 5 years, they are required.
Okay, yes, government, what do you think?
Here,
Let them minus 5 years.
he was appointed by the SMGT member, and the SMGT has no power to appoint member. So,
What do you mean they have no power? This is as per the office memorandum. Office memorandum says that you will execute agreements with SMC.
the agreement was executed by SMGT and the
Correct? Is it not in pursuance to the web?
so sometime is required, we will file our agreement.
There are 2 of the office members specifically stated now.
Mr. U. Sharma, Learned Council, Standing Council, Education Department, prays for some further time to file, obtain, complete his instructions and file affidavit. Mr. N. Bora, Learned Council for the petitioner submits that petitioner has been terminated, he's been terminated.
Right.
And is without any, is he employed in elsewhere? Is he working somewhere?
No. On the other hand, my lord, there is a, my lord, yeah, thereafter, my lord, he came before the honorable court. On honorable court directed to the director secondary pass an order. And director secondary pass an order, which has also fell in, case 36. He says that he is not, my lord, case 36, my lord. Earlier, because came before the honorable court, before by honorable court directed to pass an order, by speaking order, and secondary division pass an order, my lord. How can we now escape from this matter? Escape from this. Person to the selections and.
Let the affidavit be filed within 2 weeks from today. Matter will be listed after 2 weeks. 2 weeks.
Fix it there.
11th September.
Item number 8.
Yes. This is submitted by Learned Council for the petition matter stands passed on. This purchase appears for the respondent.
Items 9 and 10.
Yes.
460. What has happened about the private respondent because the government for provincialization. Reading of that, reading of the postal social status teacher. But in the other case, the economic to the director signed the agreement. Taking that
You are referring to which case?
item number 10.
Item 10, no problem. Yes,
So WC number 445.
yes. Yes.
I mean, I did not know the petition, I didn't know. But the private respondent is also final petition, that is not item number 10. Where the director is final.
What does the affidavit say?
It says that is not entitled to the post and
Who is not entitled?
not entitled.
Who is not
The
entitled?
private respondent, in my case, that is the petition in item number 10. But in paragraph 4, they have indicated whose names were sent to the 10 fellow. I am the state number 1 fellow. Adiba Rahman. Then we got Abdul Majid Mullah. Then we got the petitioner, Shomikul Islam. And after that, when the DLC, after verifying the various records, for SLC, after verifying the record, recommended the following persons. That is me, Miller, and 2 other persons. One is a science teacher, and another Miller, Abdul Majid Mullah.
You are Azibar.
Adiba.
Then why have you filed the writ petition? Why have you filed the writ petition?
I felt because I was not being given the order was not being passed.
Now,
And we approached this honorable court. The position is that the final order has been passed. Because we approached this honorable court.
there is some interim order.
Well, to my knowledge, no, but then there is but if the cases are pending, they do not pass any orders to the provincialization.
No, there is an interim order. You are respondent 8 here.
Yes, yes.
Your provincialization is stay.
Now, the other 2 persons have already been appointed for the provincialized on 5th February 2020. That will also be finding in my petition that item number 9 at page 19 and 20. But I have been left out. That's why I
You've been left out because there is an interim order.
Yes, that's why I filed a subsequent writ petition.
No, your filing subsequent writ petition can modify the interim order unless you pray for modification.
Here, that's what the stand here is the director, but that is not eligible. The private respondent is not eligible. That's what they're taking.
Rules for the petitioner in the second writ petition, item 10.
Petitioner, second petition, but they do not get. They're not present.
We will dismiss it.
A Jane, 1 K M K MSK Jane. Not wrong, my lord, maybe in the last 1 or 2 occasions also they did not appear, but I am wrong, absolutely correct. If I remember correctly, my lord, perhaps. I was senior to him.
But you also did not file any vacating petition. It was an ex parte order. You were not concerned to getting it vacated. You have instead filed a separate writ petition. So your writ petition, you withdraw or we dismiss it. Because you are praying for direction to the respondents to issue orders, which can be done in view of the interim order passed in the second order. writ petition. What is there to decide? You have filed with a very limited prayer. So you,
Because what is happening, the director is taking a stand on his knowledge, what he will.
that's a different issue. So the question of whether the petitioner in the second writ petition is eligible or not is to be decided. If we hold he is eligible, you are not eligible. That order goes, if you hold that he is not eligible, your order remains. What is there to be decided in your petition?
But my reputation, because since some scans were taken, that's the reason I find.
You are entitled to file. Bring it on record by way of an affidavit if you want.
Because in this case, in this case, Mr. H. Ali representing. I don't have to be there, but there is some difficulties. His son-in-law there, perhaps someone thinks in the school matters to get to here. I'll get the information.
What instructions are necessary? Look into your prayer at page 15.
It's not on the provincializing and the provincializing. And the interim order is there, so far the interim order is concerned, the director is taking a stand on his.
So government has taken a stand in your favor,
Yes.
but that order cannot be passed because of an interim order passed against you in 2020,
That's right. But
and you have not filed a vacating petition.
not quite that.
So therefore, we close this petition. And we fix the other petition for hearing if you want.
No, that is not the living, because this petition.
Why?
Because there is no prayer as such for my, on my behalf.
Doesn't require because the government says you are eligible.
That's true, madam. I said, if I'm otherwise eligible also, therefore, this petition, madam. That.
It is only in the event that the government holds that you are not eligible, that this petition is maintainable. You have prayed for a direction to issue orders.
Yes.
That recommendation has already been taken care of.
That is there, but since the order has not come about, that's the reason that the order.
Order cannot come in view of the interim order.
That's true, madam.
We withdraw this petition.
It's in next week, madam.
Wednesday, 23rd, at the request of Mr. M. Dr. To complete his instructions in respect of pursuing with WPC. What is that number?
4868.
4866.
Sorry, 48.
4686,
21.
2022, 2021. List on 23rd. None appears for the petitioner in the second writ petition. 2, 3, 4, 5.
Right.
That writ petition should be allowed only in view of this unique number.
Item number 11.
And number 1. Kindly pass the matter for time.
This is our rank for 3 years. Can we have it in the next week?
We have no emergency election. That can happen faster than
Let it be next week. As requested by Learned Council so and so. Matter be listed on, you give your dates, we'll take it up, 23rd, 23rd, we listed on, all right, 24th, 24th. Listed on 24th.
Items 13 to 15.
What is the matter, Mr. Chaudhary? What is the matter?
He is a professor of some university. In the first expedition, they came the border, why we say that we removed from green shape. And in order of it was already disclosed. And it was removed. Challenging that the neighbor order the first The second requisition is minor. After this, these orders minor, it was placed under suspension. It was placed in the suspension in August 2022 and still continuing.
There, the affidavit is not filed.
It is
Filed. Not in the first repetition.
in the first requisition, there is no file minor. In the second requisition, there is same minors, the three command. In fact, minor, the honorable give number of people who are filing it. Then minor submit to take the responsibility. And the third requisition is minor, when the disciplinary proceeding has been initiated, he asked for certain documents that was refused.
Okay, we can hear it if you parties are ready to hear. Yes,
Kindly pass on the.
all right, pass over. Is it convenient for you, Mr.?
Or maybe minor, your machine can fix a date.
No, fixing it today is the date was fixed today, is not available. Let him come. We'll see.
Item number 16.
Yes, Mr. Bhai.
I know what has happened, unfortunately, this is the fifth round of litigation. For the post of, provincialization of the petitioner as well as the private response. What has happened, if my lord will be pleased to turn to page 73.
73.
73,
Yes.
is the order of provincialization of the present petitioner before my lord. Now, being agreed to this provincialization order, the private respondent preferred a requisition below and responding to the interim order passed below at page 75. This order of provincialization was, stayed, not cancelled, until further order.
Yes.
Now, again, this requisition has been finally disposed of, at page 76, annexure 21. It is a very detailed and deliberate, and hearing has been done and order had also been passed. My lord, to save my lordship precious time, my lord can skip the new part and the relevant part starts at page 88.
Yes.
Page 88, paragraph 19 is the finding of the honorable court below.
Yes.
May I read below?
Yes, yes.
According to this court, holds that the validity of the order dated 22/09/2016 will depend on the decision that will be arrived at by the Commissioner and Secretary to the Government of Assam Elementary Department on undertaking the exercise as directed therein above in so and so and so and so. After undertaking the such exercise as directed by this court, the Commissioner and Secretary to the Government of Assam Education Elementary Department will issue a speaking order and regard the claim and counterclaim made by the above named three teachers, and also with regard to the validity of the order dated 1/2/2016. In other words, the validity and implementation of the order dated 1/2/2016 and dated 22/9/2016, impugned in this requisition will depend on the press order that will be passed by the Commissioner and Secretary to the Government of Assam Education Elementary Department. After undertaking the exercise and directed above by given due opportunity of hearing to all necessary parties, including the
the dates and time, venue of the hearings will be intimated to the petitioners well in advance. Since the matters were pending since the year 2016, it is expected that the Commissioner and Secretary to the Government of Assam Education and Education Department will hand over to undertake and complete the under exercise as directed during a as early as possible, preferably within a period of 3 months from the date of receipt of the certified copy of the order. For accelerating the process, the petitioner may furnish a certified copy of the order to the client to client. The petitioner are also at liberty to submit an individual representation before the Commissioner and Secretary to the Government of Assam Education and Community Department, along with the documents in support of their respective cases in this for the in this judgment, this honorable court did not interfere with my provincialization order. It had been directed that they, after taking their press decision, the Commissioner will arrive at a press decision. Now, a detailed inquiry has been done, and the review order, my lord, may be pleased to find at page 92. This is the speaking order responding to this honorable court order. It has been passed. Findings, my lord, may be pleased to find.
Why was a fresh order directed?
The press order was directed that the detail and deliberate meeting was there, that regarding seniority and some other issues are there. That's why the press order has been directed. Now, ultimately, what has happened, this speaking order has also been passed. This speaking order, the private high provincialization has been kept intact.
What happened to the earlier order? Matter was remanded for a press decision.
Press consideration, and this is the press consideration at page 92. And in this press consideration also, my provincialization, as a teacher, as a science teacher, had been kept intact by the Commissioner and Secretary, by the Joint Secretary to the Government of Assam Elementary Education Department. But the private respondent was not satisfied with this order. They again preferred a repetition, at page 95 and 24, and this honorable court has held that the direction which has been passed by this honorable court was not complied in total, was not complied in letter in spirit. Therefore, a press direction has been issued that the original order passed in this repetition should be complied with. Press speaking order is required to be passed. Now, what the director has done at page 25, page 102, annexure 25, the last impugn speaking order has been passed, and in the impugn order, what he has done, we have been categorized as all similarly situated, and my post for press provincialization has been directed under the 2017 Act. So, I agree with that, we have preferred this repetition. Till date, my original provincialization under the 2011 Act has not been interfered with by this honorable court nor by the director. Only, if my lord will be pleased to find the decision at page 103, that is the last decision of the director. In view of point number 1 to 6 and point number 7 and 8 of the above, the Director of Elementary Education Assam will process the matter of provincialization of services in respect of the petitioner, so and so and so and so, as well as respondent number so and so, as per the provision laid down in the Provincialization of the Services Act 2017, with due recommendation from the concerned district scrutiny committee, and by placing their proposal before the state level scrutiny committee for further verification as per the Act of 2017. My service has already been provincialized under the 2011 Act.
Now, is there a stay on this order?
No, yes, there is a stay order is operating in this speaking order,
Yes.
and as a result, what has happened, my original provincialization of 2011 is still holding the field. So, therefore, on the last occasion, my limited respectful submission before my lordship was there, that is, my current salary, they may be paid, and the final outcome will, decide, as I am a provincialized teacher at this moment,
Yes.
Would the earlier validity of the order, but it was not given a final consideration. Dependent upon the outcome which has to be on the basis of the speaking order will be passed. And the speaking order will not differ. And now, as the provincialization act has been started out. Now it is the 2017 Act under which the consideration has to be given. And that is what the finding in 102 is.
You will find page 103. Right, read from serial number 6102. In compliance of Honorable High Court's common order dated so and so league case number so and so, a hearing was conducted by the Special Commissioner Elementary Education on 9/9/2021 with all parties concerned. Considering the report statements of the DA, BO, headmaster and petitioner concerned, the government in the elementary education issued a regional order by data dated so and so, dated 12/11/20 with the following. The service of Sri Soriful Islam was already provincialized as science teacher on so and so white order dated 22/9/2016, which was issued prior to declaration of the relevant Provincialization Act and aspiration by the Honorable Court. The stay order issued dated 9/11/2000 may be withdrawn. Since Assam Better Educational Institution 2000 is no longer exists, the Director of Education may examine the matter of provincialization of service in respect of Koromali Sheikh and assistant teacher of Gurukul Islamia MEM under the provisions of the Assam Education Provincialization of Service Act 2017 and submit proposal accordingly. Since the Assam Education 2011 is no longer exists and Moinul Haq was holding an additional post of assistant teacher in so and so, the claim of Moinul Haq for provincialization of his service as assistant teacher cannot be considered. The High Court's order dated 7/2/2020 passed by the Honorable Guwahati High Court in Gandhar directed the Special Commissioner to take a decision on the validity of the order dated 22/9/2022, which apparently was passed under the Act of 2011. It should have been 2016. 22/9/2020. It is 20. It should be written 22/9/2016. Which apparently was passed under the Act of 2011. Therefore, a decision be arrived at without taking recourse to the aspect of the Act of 2011 has, in the meantime, been declared ultra-virus. Accordingly, the regional order issued so and so was revisited under the provision of the Act of 2017. As per Section 24 of the Assam Education.
Initial provincialization was which order?
22/9/2016.
That was during the currency of the earlier act.
Page 73 my lord may kindly carry the law.
So that was challenged in the first writ petition.
That was
Matter was remanded to the authorities to decide. Then what was the finding of the authority?
This is 22/9/2016. Speaking time now. Is 88 for Para 90.
88.
Page 80.
Para 90, yes.
The court holds that the validity of the order dated 22/9/2016 will depend on the decision that will be arrived by the Commissioner Secretary to the Department on undertaking exercise directed herein above in WPC number so and so and so. After undertaking such exercise as directed by the school, the Commissioner and Secretary will issue a speaking order as regarding claims and counterclaims by the imposing three teachers and also with regard to the validity of the order dated 1/2/2016. So the provincialization order, the final consideration was kept in a bench. In the decision will be taken by the Commissioner Secretary in his speaking.
But why? Why was the direction passed?
Because of the inter-se dispute between the parties. The court did not, this honorable court did not enter into the merits and decide whether the petitioner would be eligible or the private respondent would be eligible.
Very
It
correct.
was relegated to the
So thereafter, the matter was decided by the authority twice. In both the situations, the authority came to a finding that he ought to be provincialized. But then his provincialized now has been given effect under the new act. When it ought to have been given under the old act because his case was considered during that old act.
because the Provincialization Act of 2011 has been declared to be ultra-virus. So as on date, the day when the consideration has been given, the act was not.
No, the consideration to be made by the department is with respect to the claims of the petitioner which arose under the earlier act. So Therefore, there was a decision taken earlier, which the court said, let it go back and be decided again. But there was no finding of the court that the claim of the petitioner did not arise under the earlier act. So when the department takes a decision, that decision will have to decide when his claim arose. There is no finding that this claim did not arise during the currency of the earlier act.
24 of the 2017 Act.
Mhm.
Section 24.
Yes.
Of the 2017 Act. The repeal clause.
What is that page number? 131,
Page 122.
126. Yes.
Where? The appointment of the
It will be
provincial
covered by the last line.
shall continue and their cases shall be reviewed as per the eligibility norms set forth for provincialization under the act. Because one of the when the act was declared unconstitutional, it means one of the all orders falls under that act. So because of that protection in the review.
Except whose cases were provincialized prior to 2016.
Yes. Shall continue. Shall continue till their cases shall be reviewed as per the eligibility. So that the order passed under that act has also not been given a final acknowledgement that these orders will stand.
You will decide a claim on the basis at the time when the claim arose. His claim arose during the currency of the earlier. The fact that you did not decide it or did not decide it correctly cannot be used against him. He will not take away his right. Will it take away his right?
True, but your worship.
We have taken, no, it is not a case that his decision was pending. You have taken a decision. Rightly, wrongly, you have taken a decision. Now the court has remanded the matter to take a fresh decision. With what? With regard to his rights arising when earlier when the act was in place. So you are deciding his rights with effect from the date when he claims that his right arose to be considered for provincialization. So those acts will be protected. You can only say that his case will be reviewed. Notwithstanding, assuming he has a right, his case will be reviewed. And if you review and find that no, his claim is not maintainable, you can certainly take a decision. Prima facie, as it appears. There must be some finding that his right is with the act being directed ultra-virus and also taking into consideration the protection given, he will have no claim on these rights. That decision perhaps is not there in your last order. There is no finding of the court also. Court did not give a finding that.
Court did not give a finding with regard to the claims, the claims of either of the parties.
No.
And that was also not the mandate of the judgment of the honorable court.
So
Which actually consideration.
do you want to you have not filed any affidavits.
We are not finding.
You don't want to file any counter. Mr. Will you please take us to the first order again?
My lord, the first order is at page 73. Order of provincialization.
73.
The continuation of this.
This is an order passed on which date?
This is the order 22/09/2016, before scraping out of the 2011 Act.
Act was interfered on, held to be ultra vires on.
It was declared on 23/9/2016.
Huh?
23/9/2016.
Next day,
My lord Chandan Kumar Nayok and other.
next day.
Fortunate enough, my lord, it's saved by one day. My lord also very keen to find in page 103 regarding the date of stripping out of the earlier act. Page 103. In paragraph, page number paragraph, where it's struck down by the Honorable High Court by order dated 23rd in time. My lord, in Chandan Kumar Nayok judgment. My lord, the review petition which has been prepared, my lord, pursuant to this Chandan Kumar Nayok judgment. My lord, the stand of the government, my lord, that those persons whose services has already been provincialized, my lord, they may not be disturbed. My lord. Then in that review petition also, my lord, this honorable court has clarified, my lord, that till a new act is enacted, my lord, the services of those persons, my lord, who were already provincialized, they may not be disturbed. My lord. And that's why, my lord, this section 24 has been inserted regarding a review exercise, my lord. But the government is kind enough, my lord, that they are not disturbing any of the employees until that review exercise has not been carried out. And only, my lord, I as a singly, my lord, although my services have been provincialized, there is no interference of this honorable court as well as by the authority, but my salary still date has not yet been paid. My lord.
What is your name?
Sorry for Islam. Sorry for science teacher. BSc science. Royal. I'm a royal combination.
What is the finding of the department in respect of the observation of the court in para 12, para 12, page 85? Para 12 and para 13. 85, 86.
They are done what expires for the above is that there are two sets of appointment orders and approval orders. One appointing formally as science teacher and another appointing Procedural Islam as science teacher process schools. Obviously, there can be two sets of appointment orders and approval of the order appointing two persons against one post of science teacher, but apparently this has accrued to be presented. However, it seems that this aspect was considered by the Director Elementary Division and reflected in the June order dated 1/2016, wherein he made certain observations which read as unwritten. Another appointment letter has been shown to be issued by the School Managing Committee on 27/1991, appointing Rahman Ali Sheikh as science teacher by the same resolution of the same School Managing Committee as mentioned above, which seems to be doubtful as the signature of the Secretary. School Managing Committee appears different from that seen in the earlier appointment letter dated 1/7/1991. Again, this second joining report shows that the teacher joining on 11/7/1991, which is prior to the issue of the appointment letter, and the service of the petitioner Sri Farman Ali Sheikh as assistant teacher and respondent number 7, Procedural Islam as science teacher, may be considered for provisionalization. The DEO today is hereby requested to release all consequences benefit to Farman Ali Sheikh, so and so, so and so. As per the Special Education and Institute Provincialization of Service Act 2011, amended in 2011. With regard to this, this. Finding. Neither is in page 92 speaking order nor in the 102 speaking.
So certain portions of the directions of the code were never looked into.
One of the, may I draw my left allowed me, I beg to draw my left lordship that is on page 67 and 16. Then, because a small order, because
But there is no finding of the code to say that he has no claim under his claim was only doubted
That
in,
aspect,
in view of the factual dispute of having
that
to,
aspect was never been argued in.
could not have been because it was,
Because it was the only the interstate dispute between the parties.
no, it was argued during the currency of the earlier act. Matter was disposed of, when was the matter disposed of? No, I think it is after the act being declared,
28/1/2020.
after the act. But this was never urged.
There is a difference.
So you pay the current salary. Whatever current salary he is entitled to.
But if the current salary has to be paid, has to be in the nature of under the 2017.
Whatever you pay the current salary.
under the law, it's going for the.
The lordship file page 103 under the decision.
The last decision.
Will process the matter of for provincialization in respect of the petitioner formality, module of as well as police. Meaning thereby, under the 2017 Act, by this speaking order, the cases has been taken up for consideration. Not yet provincialized under the 2017.
Only the petitioner.
Even Sorry, is not the petitioner.
Petitioner was provincialized, but these 2 persons were not never provincialized.
Removal of the petitioner service was provincialized earlier, but by the this honorable court, left the finality of the provincialization to be decided by the speaking order.
But this is contrary to the finding of this code. In page 88.
Para 19.
Para 17, end of para 17. However,
Since the approach petition are being disposed at this stage in the manner as mentioned above, the order dated 22/9 and now being implemented. However, only after the decision is arrived at by the commission.
so that decision is only to find out whether against the same post how 2 orders have been there. But the court has returned a finding that order can be implemented subject to the inputs coming in. So this order was.
19 first line then. Para 19 first line.
Yes,
The court holds that the validity of the order will depend on the decision that will be arrived at by the
correct. So the validity only with regard to that factual finding.
So validity when 22/9 order is a provincialization.
Correct. So that provincialization order, if you have to read Here, you cannot read para 19 in isolation. You have to read para 16, para 17. So the court is of the view that the only reason why the matter is remanded is because of a factual dispute. The court has not returned any finding to say that this provincialization order should not have been implemented under the earlier act. That was never an issue. So the department is now required to decide whether the factual issues are in favor or against it in order to implement this.
That consideration has not been taken.
So that consideration has been done in the last order 108, 103.
103.
But you have proceeded to provincializing under 2007.
The issue is which has been pointed out by the honorable court regarding the validity of the appointment. Those issues are also not being decided.
Maybe assuming those issues are decided, insofar as the petitioner is concerned, if it is decided in his favor, then you implement the earlier order, 22-9-16. If it is decided against him,
What has happened, my lord? Under the 2017 Act, everybody has been acting. Because there was a category, there were two teachers who could have been acting. Now 2017 Act does not.
how does it alter your position in respect of being?
Under the 2017 Act, it will go by the number of enrollment. Because the seniority criteria is not there under the 2017 Act. So if the enrollment will not permits me for my provincialization, then I can give. Now, they still the exercise has not yet been carried out, and as there is a stay order is operating below. Because my service the cause of action below, the whole grievances and the cause of action arose when this 2011 Act was governing the field. I mean, as my service has already been provincialized, that provincialization order has not yet been struck down by any of the authority, nor by the director, nor by the honorable court. So that's why,
Your affidavits are necessary.
at least, for my survival by virtue of my provincialization, at least current scenario,
You will take 1 to 2 weeks time, you can take up for finally.
and current scenario may be given.
Current salary because on
On what basis?
On the basis of my initial provincialization. That is not.
That is a tentative finding.
Matter of challenge.
That is a tentative finding. We may not return that finding subsequently. Prima facie, it appears that yes, your provincialization under the earlier order was not interfered, was not doubted by this court.
Yes,
Only issue was whether this factual information which is not forthcoming, whether these factual issues will come in the way of the provincialization.
The department is required to decide regarding the dispute of the private.
The filed affidavits heard by an counsel from the department. Mr. B. Kaushik Lanan, standing counsel. Will file an affidavit on behalf of the department explaining, clarifying the stand of the department regarding the findings arrived at by this court by where is that order, page number? Arrived at by this court by order dated 28/1/2020, passing WPC number 6530/2016 and other connected petition. Whereby the initial order of provincialization of the petitioner, ID order dated 2209/2016, was not interfered with. But it was held that the same could be implemented only upon the the department examining the matter again, revisiting the matter again on on the question of revisiting the matter again for finding certain questions which arise on facts and which can only be determined from the records available with the department vis-a-vis the records available with the school, concerned school. Stop. In that view of the matter, the respondents are directed to file their affidavit within a period of 2 weeks. And interim order passed earlier will continue. Matters be listed after 2 weeks on a date to be fixed by the registry. Mr. You're already given an interim order of stay. The question of payment of any current salary is left open to be re-agitated, if so advised by the Learned Counsel for the petitioner on the next return meeting.
Time being items 13 to 15.
Yes, Mr. Your pleadings are complete.
Yes, possibly five, visiting one page. That will cover all the cases. Here, once it, it's the official having. Please proceed, proceeding as considering. Next, we want to kind of information there was an application. And because we required some other documents to file it. Here we have, we said that all the documents which we relied in the charges. Now they have found that some other documents are required for filing it. Reply against the charges. This is the
Proceedings have not been completed.
no, it's not filing, it's not.
Is there a stay?
Yes.
Is there a stay on the?
Second process, order directed not to file, reply, in the material.
Where is that order?
Considering 8377.
8377.
8377. To rule 14 of 68, very clear. You have to supply. So that,
You have not filed any application for vacating. Or you have not gone in appeal.
Since the matter of the final disposal.
We'll admit and fix it for hearing. The urgency is there, but you are not proceeding in the matter. You have your remedies.
You have not find any, since the matter is take for final disposal. Let's file a fix for.
That's why final disposal at the admission stage? 22 matters. Roll hearing matters are pending.
So that is already not the nature of the case.
Nature of the case is a departmental proceeding, let it proceed.
We have not filed in the.
He is not filed because there is an interim order,
Yes,
but you have not filed any application for modification of that order. No, we are not advising you to do that.
No, I got. But since the matter was the principal final disposal. Consequently, it's surface network.
Our general counsels for the parties matter be listed for admission hearing in the month of November.
September. The pension of supplementary subscription allowance is not being paid, 50% being paid.
You are enjoying a stay order not to file a.
Because of the reasons, sir, because we have otherwise we will lose. That's we gave us the reasons not buying, not filing. I'm doing everything. No, sir, they did not. I'm out of my job, madam. And we'll show how this suspension order and everything that was.
All right, give us a date. In September. 19th September. 19th September.
Can you tell me?
It will be on 19th. 19th September. Endeavor is to be made by both parties. For a proper hearing in on a. Therefore, we wanted to admit and fix the matter for hearing so that you can have your. This matter may not be completed in one day. The 3 writ petitions.
No, the matter is very short and simple. That is entitled to additional document. We have not relied in our. There are big judgment of.
Let it come on 19th, we'll see. 19th.
Item number 17.
Thank you very much. Regarding appointment of insert principal minor. And we don't have English. Petitioner is the senior most person.
Yes. Who has been appointed? You, respondent, private respondent.
This one number 5 would be.
I was appointed, my lord, and I have taken what I filed an IA, but then IA lottery will be there in the main matter. The interim order was passed on 9/9/2022. But well, before that, my lord, on 1st of September, I have already joined. That's why IA was filed. So,
Yes, thank you for your respect and this. This thank you for money. That I have, yes, at financial number 1.
Yes. Yes. Your MA, you did not take departmental permission.
Yes, my lord, that is there was a first student, my lord. The departmental permission I have taken, my lord, and that concern offered that this number. I have updated my lord, Thank you, that is 29, my.
Yes.
Earlier, I was talking in a every school, my lord. The school has been marked as English. This 29. So this is the difference. And he was the concern officer, my lord. Sometimes about that side.
What has the department said?
Department said, my lord, they have not taken permission.
Then
But my lord, the department has wrongly, my lord, and this evidence because this is my lord. I have taken permission for any my lord.
Madam, in the page 30
of
the petitioner.
page 30 of
Page 30, annexure 9.
writ petition.
Yes, madam.
Yes.
The petitioner is on reputation for BEd examination. For BEd post.
That is the question.
No. The page number,
17.
where is that? 17. Where is the permission?
Is 29 is certificate.
Where is the permission?
That is permission.
29.
29.
29 DEO has given permission.
Examination.
DEO has given permission.
Yes.
What do you say?
Elementary education.
Madam, the petitioner taken parliament in the year of 2017. And my lord, his master degree is completed 2021. And in the meantime, in 35/2018,
He has done on deputation for BA
2018,
2018, annexure 9,
and the permission is taken for 17.
2017. And master degree is completed 2021.
Yes. What do you say?
Then my lord, his second PhD degree also, then my lord.
And moreover,
his
he has
second
worked and
Ignore my lord, MA.
Master degree is for how many years?
Master degree 2 years, and my lord.
2 years.
1 year.
So you in 2017, you were given permission.
Yes.
2018, you went on BA. You went to pursue BA. BA is for 1 year.
Is completed, my lord, for Ignore he has completed.
Open University.
That is my lord, his MS certificate.
Now, 2017, you have given a permission to pursue MA. It is not indicated in your certificate that it is valid for 1 year, 2 year, 3 year. You given permission.
Hello, dispute is not on that. In fact, he was working in a MIS and the director, elementary and education officer was the officer who grants certificate to the any school teacher. But he, he is now here the any school has been later marked with his higher secondary. For the higher secondary, he was to have obtained the permission.
He has obtained it from some official. This is not denied.
But the dispute is not there.
Dispute appears to be there only, page 34.
No, dispute is whether he has the qualification to hold the charge.
That's right.
That's right.
So, page 34,
No, it is not that.
Therefore, my lord, I have placed another letter, my lord, because.
why the qualification is doubted?
Because, my lord, what is required under the rule is that he must have 17 years experience working in a higher secondary school. That he did not have.
That is my lord.
That is
Had
the
requirements, my
rule.
lord,
That
that
is
is
rule.
negated, my lord.
And seniority is not required in case of appointments of experience.
Let me place that.
That is the dispute.
She has my lord joined in my lord. This 34, my lord, she has joined as my lord senior Hindi teacher, not as graduate teacher. I have joined as graduate teacher on 1st of January 1992. But she has joined 23rd of May 1992 as my lord senior Hindi teacher, not as a my lord graduate teacher. She has graduated in 2011 or 12. Her post was sanctioned as graduate my lord in the year 2004. When she got even graduate, 104 my lord. Page 104. Her post was sanctioned in 2004.
Yes. What is 104?
Yes, my lord. It does my lord.
104 is 104 is a communication 29th April.
104 my lord, start.
That is not 104.
Serial number.
There is a chart at 100.
Obligation, we have my lord. Signature and contours, which is there, it's valid there.
What chart? Who for what document?
Annexure 6, fine.
Annexure 6.
Um,
Of what?
of addition of it. It is my lord. Dependent reply, man. Dependent reply, file verification. There are two sides.
Yes, 106. There is not 10. Annexure 2. Is it?
Annexure 2 is one side, my lord. Regarding the appointments, you are appointed in 23rd of May 1992 as well as Hindi teacher. And another side you will see.
Annexure 6. Yes.
Here, my lord, our post was sanctioned in my lord 2004. 2004. 12 March 2004. And she has graduated my lord in the year And between valuation of this 16 and 6 and Excel. What is it that the first October?
I have not understood what you're trying to point out from the chart.
Short mind of Krishna Gwala.
Ah. Yes,
Here mind of the permission granted mind of for post creation number, headline is post creation number.
2004.
Yes, 2004.
So,
So I have joined in a regular post mind of that is a science teacher. Mind of in 1st of January 1992. And she has joined. She have graduation from 2004 only. From the tuition purpose, not prior to that.
why do you say, what post is this? Assistant teacher, Hindi teacher?
Hindi teacher.
Ah.
But she has graduated and my 2011.
Where is your name here?
My name is not here because my post was regular post when I joined.
All right.
When I joined, my post was a regular post. I joined as science teacher.
Then whose chart is this? This chart?
Issued by the inspector. Inspector.
No. This chart at page, yeah, is your paper, page number 96.
Refer the subject cited.
Kindly come to page 96 of your paper book.
Page 96. Date of initial appointment. My number, name is the serial number 1. The 1st of January 1990, I have joined in a manner regular post.
And what about
She
the,
has joined
Ah.
on 23rd of May 1992 as Hindi teacher. I joined as assistant teacher. And she has joined as Hindi teacher. She was not graduated at that time. She been graduated on 2011.
no, kindly see the column number 8. So date of joining as graduate teacher.
Column number 8, date of joining as graduate teacher. She was graduated in Hindi matter, not as graduate qualification certificate I have enrolled by.
In the
Graduate, she has
Date
graduated
of-
in 2011.
Date of receiving graduate scale of pay.
Certificate from the university. We are not a- But anyway, I am senior because I am first January and she has joined in 23rd of May. So anyway, I am senior one. There is no dispute that I am the senior.
All right.
And regarding the permission, as in the one of, at that time, I was the district elementary education officer, the appointed authority, not the director. During his appointment 92. So he has issued the certificate.
Now, what happens to the experience?
Regarding 17 years, my lord, that
Yes.
is the decision. Even that said, my lord, therefore with the rule, my lord.
Interfere.
Number 2019, 105 This 5 And here one is there, one of inside, for the postal inside, not for the permanent principal. The one of the rights, then you're having possible. Therefore, for effectively, and will not engage in any manner, any recruitment process previously under the defined between graduate teacher in high school, between graduate teacher in higher secondary school, and for domain for acceptance, and the same cannot receive judicial.
Why don't you give a list? Why don't you give a list of books? No, you don't, we don't need your books. You just give us the citations, we'll take out the copies.
Addition is my lord, 2091 jail.
Hmm.
91 jail is 583. Of the Assam Secondary Education Provincial Services 2003. Instructions for the purpose of the controversy with permission. Referred to the province of the previous regarding 17 years interval of higher secondary school. According to us, with regards to the provision of the 2000 rules, there is no difference between a graduate officer working in a high school and a graduate officer working in a higher secondary. Higher secondary or multi-purpose school, and therefore, rule 1223 in our opinion is discriminatory and violative of Article 14 and 16 of the Constitution of India, as there is no rational and intelligible difference in making the graduate officer working in higher secondary, high school, higher secondary, and multi-purpose school for appointment and principal of higher secondary.
What is the name of the party?
Provincial and others. Paragraph 20. Paragraph 20 and 21.
Yes, please carry on. Please carry on.
While setting the rule for the graduate research working in Ashby. Considering the matter is in entrance, we are of the opinion that ends of justice will be if we read into the rule 12, the expression high school, higher madrasa school, before higher secondary school, higher secondary and multi-purpose school, and the expression or in combination of such schools after the words higher secondary, and multi-purpose school. It's not for the principal in the higher secondary of the higher secondary and multi-purpose school. Apart from other qualifications, the candidate must have 17 years of teaching experience as graduate officer in any high school, public high madrasa, or higher secondary school, or in combination of such schools. The determination of us, needless to say, we operate prospectively and will not impeach in any manner any recruitment process previously undertaken. So, you might be working in high school or higher secondary school for 7 years.
Yes.
Another judgment matter I was this matter regarding English.
मिला कि नहीं? तो क्या? जल्दी.
2094 bill is 467.
Madam, you let us get the judgments. We'll take up your matter at 2 o'clock.
Yes, madam. I will.
Yeah. Let the judgments come. Yes. Mr. Roy, if you have any judgments, you can.
Yes, item number 18. I have copies.
Yes.
And this means worship. Commissioner Deputy Worship Party and this solar application page 1 for the
No, before you go to the judgment, tell us the facts.
Lordship. Petitioner before the lordship, he is a selected candidate. Or the department help is to are
Selected as what?
assistant teacher. Our name appeared in serial number page 42 lordship.
Yes.
Our
See-
name.
serial number?
Lordship.
235.
Lordship.
Hmm.
So these are choose. And kindly note the lordship. 236 Abdullah choose.
Hmm.
He was appointed.
He is private respondent.
No lordship, he is not a respondent.
Then,
I'm coming lordship, just that lordship, our appointment of this. Abdullah is serial number. Where his appointment page 105 lordship.
you are not challenging his appointment.
Lordship.
You are not challenging.
No, lordship, I am only to get my appointment, lordship, I am not challenging.
Then why are you referring to his appointment?
Lordship, just I am coming on that, lordship, how I described lordship since
Hmm.
lordship. Then lordship, there was an later lordship of the district elementary from that. Page 99 lordship, director elementary education Assam lordship. My name was and except to D lordship.
Hmm.
I did lordship the order.
Yes.
With regards to subject cited by direct you to comply with the order passed by the court by appointing the following petitioners as LBC teachers against the existing available vacancies at your disposal. Since the limitation of filing the review application has already expired long back, as stated in your letter, and the contempt proceedings has been pending in the Honorable High Court regarding the same matter. Lordship, my name is Kudaja Khatun Choudhury at serial number 6. Then next page, lordship, SLC approved. The other 5%, but my name was missing, lordship. Next page, page 100, lordship. Atmata Ali Choudhury, lordship.
Hmm.
My name is not there, all others, lordship, SLC approved, lordship.
No, after 99, what happened?
Then lordship in after 99 lordship, then 2001 lordship, my name was missing, lordship.
Page number 99.
Lordship, page number 99, after 99, then page 100 lordship.
Hmm.
100 lordship. I am directed to the subject cited above and to inform that the governor of Assam is pleased to accord exclusive approval for filling up the SIG LP school teacher
So whose name was
included.
included?
Lordship, one Atmata Ali Choudhury, whose name in the select list is 379.
Then you are challenging his appointment.
No, I am not challenging. I am only because to get my appointment by virtue of my selection, lordship. Because there was an order of the division bench of this honorable court, page 88 and 89. Page 88, lordship, in the other petitions.
Yes.
Lordship, page 87, last line, lordship, by judgment in order taken civil number terms and the batch of this court. As this court directed not to appoint any other person to the post of LP school teacher outside the list. And it was further directed the appointment shall be made till the list is exhausted. Such a direction has to be issued as in the meantime an advertisement was issued. It is first objection of Mr. Sharma and additional government to pay that the select list was this for the district of Palagan is expired on 31/12/1990. But the present petition was filed for. On this ground, the additional government advocate has raised objection. We are unable to accept the contention as per direction in the above civil rules. and the bed. All appointment in future shall be made till the list is exhausted. I just to submission, Lordship, all other appointment, all were appointed below me also appointed, but my appointment was not considered. And Lordship, particular Lordship, in the meantime, Lordship, the petitioner along with some other person approved the civil court. And civil court passed and agreed for consideration of our appointment. And there was some technical problem, Lordship, in the judgment that we have not participated in the selection. Then Lordship, page 123, first SIU proposal for SIU approval was referred to the petitioner.
Where is that? Where is the order impugned? 31/8/2022.
Oh, read your paper,
No, this order that you are challenging in the writ petition.
Lordship.
$160.
Lordship. Sorry, Lordship. Lordship. May I read? Lordship?
Yes, please.
Finding. Lordship, prior to that, may I come to the division bench order, Lordship? This judgment of the honorable petitioner, Lordship, in my case, page 155, Lordship.
Yes.
These are the Lordship done. Next page, Lordship, is that my submission. The Land Council for Development submitted that the petitioner was selected in the year 1988 for appointment of.
I think it is better the matter is placed before some other court. Because I was in the division bench.
Lordship, but my response to submission, just I am coming, Lordship. There was an order last paragraph, Lordship. Under the circumstances, we allow the appeal director the state to consider the application by the legal appellant for grant of SIU approval as per FOC.
Therefore, I'm saying.
Lordship,
Placed before.
and I only just problem the Lordship in this case,
Hmm.
by virtue of the government advocate's letter, my case was rejected.
Land Council to the petitioner. After hearing. At some length. The order dated 13/5/2022 passed in writ appeal 169 of 2022. Was referred. And which is relied upon by the petitioner. Since. By the state order, the appeal was allowed, appeal filed with the petitioner was allowed. Directing the application. Filed by the writ appellant. For grant of a SIU approval. To be considered by the state respondents. Stop. The. Order passed. Order dated 16/3/2022 passed in writ appeal 2558 of 2017. Within bracket against which the appeal was preferred. Was interfered with. In pursuance to this order. The impugned orders dated 16/7/2022 was. Sorry, where is that order?
Lordship,
Impugned order 31/8/2022 was passed. As such, the matter be placed before any other bench without me, as. This bench was part of the division bench which passed the order earlier on,
Item 19,
before any other bench.
and they are. Sorry, Lordship.
You should have pointed out. List on 24th. Yes, some instructions were sought for. Yes, what instructions?
There was a letter of 25/2023 issued by the district administrative education office on the while the certificate matter has submitted application of 29/6/2007, 2004. Except this determined of no record is
His case, their case has not been placed before the DLC.
even the office has not submitted before the DLC.
Which is the office? Which office is supposed to submit?
Kindly, you may look page 16. Hearing was my call. I got it was that I have submitted all the documents. Page 16 of my.
Third learned counsels for the parties, this petition is filed with the petitioner. Praying for direction to the respondents to
In fact, my there is an order, pillar order last page 27. These are almost different.
praying for a direction to the respondent authorities to place the matter before the DLC for consideration of an application for professional appointment. Stop. There are the petitioners. Husband, late Lovitus or Morali, died in harness on 23/08/2003. Stop. Died in harness on so and so date, leaving behind the petitioner as his widow and two minor daughters along with his mother. Stopped. Since the petitioner's husband was the person sole bread earner after his demise, the petitioner's family was placed, had to undergo extreme financial hardship, and then she applied for being appointed on compassionate ground. When did you apply?
Page 14, man. Yes, given in the moment.
Is there any date?
The date was not mentioned.
Was applied, had applied for compassionate appointment. Stop. In spite of our approaching the respondent authorities and submitting the relevant documents pursuant to the communication dated 29/06/2004 before the office of DEEO, Lokhimpur, not Lokhimpur, Oman. The status of her application has not been made known to her. Stop. Petitioner, being a poor widow, had approached the authorities time and again, but no information was forthcoming. Stop. Being aggrieved, she has approached this court filing writ petition. So, learned counsel for the petitioner submits that in terms of the OM dated 1/6/2015, upon filing the application for compassionate appointment, the matter is required to be placed by the concerned officer before the DLC. Stop. However, in spite of the mandate, in spite of the specific provisions in the OM dated so and so, and in spite of requests made by the petitioner, no information was forthcoming as to whether our application was placed before the DLC or whether it was taken up for consideration by the DLC. So. And Mr. P. Sohiel, standing counsel, the government advocate appearing for
1 and 4.
1 and 4. Submits on instructions that there is no instructions received from the office of DEO as to the status of the application. Direction to be filed. Stated to have been filed by the petitioner seeking professional advice. Anyone for education? MS so appears for the education department. What do you say, DEO? MS so learner, a council appearing for the education department. Also makes similar submissions. Where having heard learned counsels for the parties and upon perusal of the petition. The court is of the view that the matter can be disposed of at this stage with the direction to the Director of Elementary Education, respondent number 3, who forthwith pause the application stated to be filed by the petitioner before the DEO not looking to seeking compassionate appointment to be placed before the next DLC meeting for the district of Lokhimpur. Stop. The DLC thereafter will consider in case of the petitioner in terms of the provisions of the OM related 1/6/2015 and pass appropriate orders thereon. So any such order that is passed on such application being placed before the DLC, copy there will be furnished the petition. So if in the meantime the matter was already placed before the DLC and orders thereon have been passed, a copy thereof be furnished to the petitioner for due communication. With the above observation, the petition stands closed. The respondent number 2 will carry out the orders within 3 weeks from the date of receipt of certified copy of this order. Thereafter, the DLC, upon being thereafter the DLC will consider the matter as directed in the next DLC meeting. That may be held. With the above observation, the petition stands closed. Disposed of. Mr. P. Soikia, government advocate, has submits that he has received instructions from the deputy commissioner saying that no such application has been forwarded before the deputy commissioner, who is the chairman of the DLC.
Item 20,
not by illegal. Yes.
In this case, my lord, we are agreed by the interconnection on the part of the council for not finalizing the selection process initiated for filling of the criteria.
Rules for the higher secondary council.
Unfortunately, my lord, today they are need responding soon to the council. Therefore, I think.
The matter be listed again, registry to reflect the names of the standing council for higher secondary education council. Stop. Mr. Arandeka, it is for the petitioner, list after 1 week.
Okay.
items 23 and 24.
Yes.
On 28 or 30.
A joint request matter listed for admission hearing on 29. 29. Record the names of learning councils.
Item 25 and 45.
Yes, yes. We are considering the IA. Who's filed the IA?
I am filed.
Yes, any objections?
We have filed our objection. We have physical copy on the inside will go. Lordship, I grant one to stand for academic purpose.
For improvement,
Yes, sir.
you have objection?
Yes, sir.
Why?
Take up of the assignment.
All right, issue notice, so and so issue notice on the application seeking improvement filed by the applicants. So, Mr.
Can get some.
N.K. Sharma, learned counsel appearing for the writ petitioner. Submits that they have received the copy, they've been served with a copy yesterday, like to file objections. Opposing the prayer for improvement. Let,
We have filed our affidavit.
where, in the writ petition.
In the written. There is a stay order operating where they have stayed the entire process of promotion. And the person.
He wants to file an objection here.
So our promotion.
Let the matter be listed on 28th August. By which date the objections, if any, may be filed. Mr. P. Kaushik, learned Standing Council Education Department submits that they have already filed their affidavits in the main writ petition. MS so and so, learned counsel appeals for respondent number 4 and 5. Who is 4 and 5? Private respondents. So, list the matter on 28th. It's short date only. Huh? We are fixing it on 28. Let them file their objections if they want. In the writ petition, the same be listed. Again on 28 as directed, interim order passed earlier will continue in the next date. Takes the government advocate submits that affidavit has been filed in the writ petition.
Supplementary list item 46.
Last occasion, you directed the respondents to seek instruction as regards the vacancy available.
Yes, Mr. Govildar. What does it say?
Inclusion of age regarding the vacancy, I was already informed that vacancy is there. I will inform, but not the length of regarding the date of part and the age. Then our definitely say that we feel over it. But
Just on Monday, instruction has been submitted that the age was calculated up to 31st of December 2023
yeah,
instead of 1st of January 2023. And as on 1st of January 2023, the petitioner was exactly 28 years of age, which is the eligibility criteria with regard to age.
yes, okay.
Then
I saw verification of the regarding that. Some same instruction has been made. At least there is it and passed for the recording.
where is that instructions earlier passed?
Lordship, I kept it on records.
Verification,
Not available.
verification part is there. I thought for that.
But this- that we're keeping the instructions on record. It's not reflected in the order. It's 40.
Do you have the earlier instructions?
That both lordship have given that clarification also, that also I some, they have given the same letter. Whereas they have, when the lordship, they have said that they have implemented the age on 31 December 2023.
When it should have been 22.
2023.
1-1.
Yeah, yes, sir. That's for one, that's for it.
Art learned counsels for the parties. This writ petition has been filed with the petitioner. Who has applied for lateral entry to polytechnic institutions. Pursuant to the advertisement notification dated 15/12/2022 passed in Assam Tribune. Stop. According to the petitioner, according to the learned counsel for the petitioner, he has all the required qualification for being accepted for a lateral entry to the Polytechnic Institute, to a Polytechnic Institute in Assam. So there was some selection process.
Yes, madam, selection process was there and the select list that was on the basis of merit, the administered for madam.
The petitioner participated in the selection process and her name appeared at serial number 6 of the select list for the branch of electrical engineer. You're an SC candidate.
SC candidate.
Petitioner belongs to the SC category. Stop.
That serial number 6 in page 3.
Yes. However, while the petitioner was awaiting her appointment, her admission into any of the ITI, any of the polytechnic institutes on the basis of the same selection process, she came to be informed that her age, she was found to be overaged and therefore not allowed entry. So, better. Earlier, when the matter was listed, the Learned Standing Council for the higher education was requested to obtain the required instructions. So, the Learned Standing Council has placed the instruction before the court today, where it is shown that the age of the petitioner was calculated by taking 31/12/2023 as the cutoff date, when the cutoff date ought to have been 31/1/2023. As per, where does it say?
Now it is at page 21, the third paragraph.
21. As per the advertisement, which is available at annexure 3, page 20/21. So, as per the advertisement, the age limit of ITI pass student is minimum 17 years and maximum 25 years as on 1st of January 2023. And for SC oblique ST additional 3 years as per existing terms of polytechnic. So the petitioner as on date on 1st of January 2023 was 28 years. And therefore is covered by the age relaxation provided in the advertisement itself. So it is evident that on the basis of the instructions which have been placed before the board, that the authorities have wrongly calculated the age, has calculated the age by fixing a wrong cutoff date. So cutoff date taken by the authorities is 31/12/2023, when it should have been 1/1/2023 as per the advertisement. So it is further submitted by the Learning Standing Council that the vacancies are available as per instructions, on instructions that no,
That cannot be recording. Regarding second to the time of then what?
so in that view of the matter,
Yes.
the writ petition, in that view of the matter, this court is of the considered opinion that considering that this is a matter pertaining to the limited prayer of the petitioner for being accepted into a course of ITI, of polytechnic, in any polytechnic in the state of Assam for the branch of electrical. Courses have started.
Our courses have started long back, way back in February. In fact, the
The
petitioner.
courses have already started. Therefore, this court considers it appropriate to dispose of this matter at this stage without calling for any affidavits of the department. So the instructions which have been placed before the court are kept on the record. So the writ petition is allowed. Is there any specific order passed?
Yes, madam. There is a specific order passed on 12 April 2020.
Page number?
From the court.
Page number? No, by the authorities.
By the authority number, it's at page 27.
27.
27, this was the academic record card, and in the remarks column, it is written over age. That is the ground of rejection.
The authorities are therefore directed to permit the petitioner to be admitted in a lateral course. Will permit the petitioner to be for acceptance through lateral entry for the session 22-23 in any of the polytechnics of the state.
Presently, she will have to be admitted in the third semester.
Whatever. Let us not go into all these details. At the appropriate level.
Yeah.
Stop. Since from the instructions received, it is evident that the authorities have wrongly taken a cutoff date as 31/12/2023. The prayer made by the petitioner for permitting her into a lateral entry in any polytechnic in the state of Assam ought to be allowed. So the respondents are directed to pass appropriate orders permitting the petitioner to be admitted into at the appropriate level in the course in which she had applied for in any polytechnic in the state of Assam by taking or calculating her age at the cutoff date as 1/1/2023 as per the advertisement dated so and so. If petition stands allowed, disposed of.
Time limit could be fixed for all. Courses are going on.
We have directed them forthwith.
into account of her age and for her.
We have stated that.
Waiting list for orders item 26.
Yes. Where is the order?
Find the order.
Order.
Sorry. Order at page.
12, 11, 12. 11, 12.
Yes.
Page number.
11. On. The particular is 40.
What was the direction?
Medical reimbursement. Direction of
Yes.
the response to disburse the medical reimbursement amount of this 5 lakhs.
Yes, Mr. Cholia.
Yes, Lordship, here I am appearing for respondent number 1 and 2, Lordship. We had sanctioned the amount and we had ended to the higher. On the last date, we had communicated the sanction amount to the authorities, the higher education department. Because the amount had been sanctioned by the government. So it is the higher education authorities that have to clarify as to what is the status of the medical reimbursement.
Yes, Mr. Govildar. Higher education.
Some pandemic and kind of the content is pending more than 1 year because
Heard the council for parties, Mr. H. Cholia for the respondents. Health, number 1. 1 and 3 submits that the medical reimbursement claimed by the petitioner amounting to 597,737 has been sanctioned and forwarded to the higher education department. So Mr. Govildar, learned counsel appearing for respondents 4 and 5 submits praise for a short date to obtain specific instructions regarding the status of the reimbursement claimed by the petitioner towards medical expenses incurred. Matter be listed after 1 week. Mr. So and so appears for the petitioner. After 1 week, list on 25 August. Whoever is there, you get your instructions. What? First of September. 1st of September.
Item number 27.
Yes,
Order start week 11. 20% is it sale.
yes, department, what has happened?
In this matter, especially when committee has recommended the name of the petitioner also not to come of provincialization of the assistant teacher. And accordingly, it is proposal has been forwarded to the government for creation of the post. So, my lord, there was no let the party of the secretary. So now it is under the government man. This is my.
Yes, what do you say?
Order dated 1/23. Order for the respondent submitted the level committee. Forwarded statement. Yes, recommended the name. Now it is under the government matter already. Container has done her job matter and complied the matter.
Hard letter councils for the parties, Mr. Where is that recommend, where is that communication? Give it to us. Mr. U. Sharma, learned counsel appearing for the respondent number 2 submits that in terms of the directions. Sole respondent. Sole respondent submits that in terms of the directions of this court by order dated 22/09/2021 passed in WPC number 4697. The Office of the Director of Secondary Education has already forwarded the recommendation of the state level selection committee to the recommendation of the state level selection committee recommending the name of the petitioner for provincialization as assistant teacher arts in Pochim Chowkhat Ucho Madhyamik Vidyalaya, Jorat district, to the Secretary, Government of Assam, Department of School Education. Stop. Mr. Sharma has placed a copy of the forwarding letter dated 16/8/2023, a copy of which, along with the relevant documents, are kept in the case report. Considering the fact that the direction made by the petitioner, by this court, has been complied with in terms of the communication produced to the court. The court is of the view that the specific directions of the court directing the sole respondent, namely the Director of Secondary Education, to bring to its logical end the recommendations made by the district level scrutiny committee. The selection committee, no, scrutiny committee, has been complied with by forwarding the same to the Office of the Secretary, Department of School Education. Accordingly, this court is of the view that the contempt petition can be closed at this stage. Mr. So-and-so appears for the petitioner. Contempt petition accordingly stands closed. Please keep a copy of the copies of the instructions. Yes.
Item 28.
Why the I?
Paid for action for something perjury method. It false statements based on affidavit. By order dated 10/4/2023, the honorable court was pleased to grant the last opportunity. We had only granted for pending liability. Thereafter, many times are gone. Not respecting this honorable court, not at all, my lord. The different different melodies scale. I mean, another aspect is there, my lord. There is a judgment of the honorable Supreme Court with respect to the opportunity of hearing in an application for perjury of the accused person.
You filed affidavit where? Where do you want to file the affidavit?
Next week, my lord. Next week.
Where? In the IA or in the
IA, my lord.
in the IA? That will be an objection.
I am for restaurant number 2, my lord. Personally, my name is here. Criminal some criminal service. That's somewhere I have to do, my lord.
Here is, my lord, that the student was there was a disciplinary proceeding being drawn up.
No, we don't want to go. You tell us when you want to file your reply. Positive.
Which time we will file it?
Huh?
Which time, my lord? Short time of week, my lord, we will file it. Because we have to look into the record also, my lord. In this case, there are little record history.
Learned counsels appearing for the respondents, Mr. Day and Mr. Das submits that they would file the affidavit objection / affidavit in the IA within a week. Praise for further week's time to file their affidavit. So, Mr. S. Day, learned counsel for the petitioner submits that the opportunity granted or to be the last opportunity. In view of the fact that several opportunities were earlier granted. So, that view of the matter might be listed after 10 days, enabling the respondents to file their objections in the IA. List after 10 days. Give a date after 10 days.
30 August.
My lord, can we on 7th of my lord, because 1 and 2 is the 7th, my lord, 7th of September.
31st.
My lord.
Item 29.
The petitioners are seeking the appointment to the post of director in upper primary school. In the meantime, there has been a development, we have called for verification of our documents and asked for 29th of July, but we do not know what is the outcome of the verification. If my learned,
Why this I?
I was, because, it was, in the meantime, also there was a fresh advertisement for the post of teacher. And we finally hired for, paying for, keeping free, post vacant for because they were,
Weeks time, my lord, because I have been told that the verification, the inquiry report has been submitted. They are yet to take a decision.
Verification of what?
we had called for verification of the
Of the
documents. Last, month, July, 29th of July, we attended the
It is submitted by MSD Borgumai Land Council for the petitioner that during the pendency of the IA as well as the writ petition, the petitioners were called for verification of their documents by
in the director's office.
By the Director of Elementary Education Office, Elementary Education Assam. Stop. However, the counsel for the petitioner submits that they are not apprised with the final outcome of the verification that was conducted in the office of the Director Elementary. Stop. Mr. B. Kaushik, Learned Standing Counsel. Yes,
Wait for 2 weeks time.
praise for 2 weeks' time to obtain the required instructions. Prayer made, not objected. Strongly objected. Prayer made is allowed list after 2 weeks. 8th of September. 8th of September.
Supplementary list for orders, item 47.
Sorry, sorry.
Income that will be easily for 50 transfer.
Maybe not there, but new incumbent, why can he not find out whether the order has been implemented or not? Whether they implement or not is their fault. Why are you insisting that they should be implemented? You have to obtain instructions whether order has been complied.
Yes.
Mr. Pobildar, Learned Standing Council Higher Education submits that he be granted 2 weeks further time to obtain the instructions as to whether the directions of the court passed in WPC passed by the order dated 18/7/2022 in WPC 4880 of 2019 has been complied with. Mr. PH Learned Council for the petitioner does not object. Case after 2 weeks.
For a hearing, item 31.
32 years. Nine. At least for a night. Actually, okay. Yes.
Item number 31.
None appears. Dismissed for non-prosecution. Interim order is any stand again. Mr. B. Kaushik, you appear for respondents. Yes.
Item 32.
Yes.
Of this matter person pertains to payment of delayed salaries of assistant teachers who are appointed relative negative with them after they regularized in 2000. And they have been receiving salaries in 2005 after enterprise of the code. But the delayed salaries from August 95 to March 2005, they have not received. So this, we are challenging that.
What do you say, respondents?
The engagement and instruction is required whether.
What instructions after so many years? You have filed your affidavit also. Deputy Secretary Budget.
Our record has been misplaced manner. So
You take action against the person who is responsible for safekeeping of the records. Affidavit of director is also available.
Finance department will be there. And then.
Yes, Mr. What has happened?
record is the finance department, it is the administrative department.
We are giving you this record, go through at 2 o'clock, you submit. Yes, 2 o'clock.
Item 33 to 36.
For the concept of other side, taking of the emergency management.
Yes, right. What is this matter about?
Regarding the regarding post of agreement officer, inspector of school and
What are you challenging here?
in the year 2000.
What are you challenging?
I'm just telling you the appointment.
Whose appointment?
Those who have been selected. Those who have been selected and
Their parties here,
yes.
represented by Mr. Bora.
Yes, other also, when the pair minor is concerned, the one of the pair minor.
Yes.
Page 32A.
Yes.
Minor. Going to call record issue calling about respondent why appropriate reach and order directions to directing the respondent to immediately cancel appointment. To respondent 12 and issue face that are mentioned in proper call as directed by the honorable court in Judgment dated 26 2000 and next 9 passed by WC. That was my please may kindly see order my page 86. 86.
86.
That was reviewed by your lordship. By the video. Page 86. I will review and your lordship division was reviewed by.
The department filed some affidavit saying that it is not necessary. And the court recorded that it was necessary. That was reviewed.
Very good. My lord, this order has been inadvertently written, my lord, by file affidavit filed by the respondent, my
Now,
lord.
in view of this, what is your prayer in the writ petition?
Honorable school,
Cancel the appointment, issue fresh as directed by the order 2006. 2006 has now been reviewed.
yes,
So what remains now?
But the main case in this three item number 34. Is the main issue.
Main case, give us the main case.
We are advised, we are can have.
Main case,
This is the main case.
There they have challenge the appointment letter on categorically.
Let us keep the main case and close all the other not main cases. That is the main case, 34. What is the prayer in 34?
Prayer for getting into the appointment.
On what ground?
Grounds are there are not same, not flexible grounds are there. They have manipulated their documents of our certificate the application. They have been executed by the supporting documents and then that because they have filed the activity and additional activity matter that is there. Numbers of agreements are there.
Your main case is not traceable.
That is the leading.
Hmm.
That is- I
No,
cannot manipulate.
always leading this case.
So you must be knowing that the main case is not, you must be knowing that this item is not traceable, therefore you are making the main case. Up to 36. And 36 is the main case. 34. All right, at two. Take it up. Let the matter, let us first find out the main case. Not here, let us go through the main case. We'll have a look.
Many types of the matter is that kind of other than senior, because my lord, I have joined the service as gazette teacher, my lord, on 1st of January 1992, and she has joined in intermediate scale on 23rd of May 1992. Thereafter, she has been graduated only in 2011.
Yes. Yes, yes.
And my lord has post of creation in my lord. Then in exercise.
This is lower.
It has been sanctioned as gazette. Podcast created. So in any count, my lord, she cannot be my lord. Regarding amalgamation, my lord. This is the definition, my lord.
What is the finding of the division bench here? 2019.
That's my lord. This paragraph 21. According to us, having regard to the provision of the education rules, there is no difference between a graduate teacher working in a high school and a graduate teacher working in a higher secondary and multi-purpose school. And here, four, we go to three, in our opinion, is discriminatory and violation of Article 14 and 16 of the Constitution of India. Because my lord, in the ruling, this says that my lord, 17 years of teaching experience in nursery in higher secondary school. So that has been my clarified in any school, high school or higher secondary school. Total 17 years. In any school, that high school. The student is declared as violation of the article 14 and 16.
So you are senior, you're,
Here, and as.
you're also a graduate, you are receiving graduate scale of pay. And in view of the judgment of the division bench,
Regarding 17 years.
the 17 years,
Either high school or higher secondary.
now, how many years you have?
Since 92 my. 30 years. When the marks time for retirement of 2 years or something like that. Completed more than 5 years of service.
Yes,
And regarding amalgamation, madam, page 95.
what is there in what is why amalgamation?
Office memorandum dated 3rd August 2021. Under school is amalgamated.
Which, whose school?
My school is amalgamated. Higher secondary school.
Uh,
Here also seniority was restored by.
95,
Page 95 is the matter, office memorandum. The given portion at 98.
what is the date of the office memorandum?
Office memorandum is my 3rd of August 2021.
Relevant page?
98 madam. Clause 16. Garrison list, each of the teachers shall be the teacher of the higher school after amalgamation, merger, and their status will be revised. After amalgamation, merger of the garrison list of school or district, as the case may be, has to be revised by incorporating the names of teachers against the higher school in as accordance with her qualification and status. Each will get the seniority as before and in her name has been placed in the appropriate place in such a way that it does not lose in her seniority. And my lord, kindly see my lord. The next up for. Page 104, my lord. Annexa 4. There's a point mentioned that because the letter is dated 29 April 1990. Subject, the regulation of service of 500 posts of Hindi teacher of secondary school from CSK to non-plan. With reference, the letters of director state that 500 post of Hindi research were created, like so. So my lord, the post was my lord earlier, all these posts my lord are not here. Have post was created in 2004. So prior to that, my lord, she was working in, not in graduate scale, in intermediate scale. Page 108. And she has been graduated, my lord.
Yes, Okay.
and certificate.
So you have received graduate scale of pay, you are senior to the private respondent. Requirement of rule 12(2)(3) has been interpreted. And your seniority upon amalgamation also has been restored. These are your grounds.
So I'm on a date of joining, I'm getting graduate still since.
Okay,
Senior join later than me, I'm
All
still
right.
not getting the graduate. So since it is a temporary arrangement, it's not even a permanent post for interview. So the senior most is actually appointed as headmaster.
All right.
All right.
Yes, Mr. Roy. Your objection with regard to 12(2).
My lord,
Have you gone through the
no,
agenda?
my lord, no, I've gone through. I've gone through, and I'll think, I'll feel. My lord, we'll first take the rule. The something in the education provincial rule, 2003.
Page number
Page number in my book, 376.
376.
376, will not come to relevant, rule 12.
Yes. Yes.
Well, rule 12 is the rule with regard to recruitment principal of higher secondary school, and rule 14 with regard to vice principal and headmaster. Well, I read first rule 14. Well, only the beginning. The well, got the
No, this is a post for what?
principal, and I'm making a distinction difference. Well, there's a difference between the recruitment rule between of vice principal, headmaster, and principal. Rule 14 says recruitment of the post of vice principal, headmaster, so and so. And says, rule 1, the post of vice principal shall be filled by promotion on the basis of combined seniority. You should take note of this seniority. This vice principal and headmaster is based on seniority. My lord, come to page rule 12 now.
This is in charge.
He said,
This is not regular principle.
my lord, our High Court has the decision that one must have the basic qualification to hold
Correct,
post
correct.
structure.
Correct.
Therefore, my lord, I will say, Lord should kindly come to say rule 12.
Hmm.
It says, rule 12 says the post of principal in a provincial high school shall be based on direct recruitment. This is the direct recruitment, it's not based on seniority. And
This is not a regular selection.
regular selection.
This is in charge.
But not in order to hold the post of regular post.
You show the disqualification.
I am showing them.
Yes.
What you will kindly see that it says clause 3, a candidate must have 17 years of teaching experience.
Hmm.
So he was appointed initially on my lord, his appointment is 31/12/1991. My lord will come to his appointment letter page 24.
Yes.
Also will see the order. It says, what it got it? It says in person the government letter number so and so. Sri Shantanu Kumar Das, the petitioner, passed BSc. Hereby temporarily ad hoc basis as science teacher in the scale of so and so. Class of an also admissible under the rules in Budon any school.
Hmm.
He was appointed in any school.
That has been clarified by the division bench judgment.
I know. Division bench has clarified high school and higher secondary. Not any school. And my lord, after amalgamation, the teacher of any school is to teach only from class 1 to 8. And not above that.
What was the requirement earlier?
My lord, earlier it was only, my lord, requirement was
I see.
17 years of graduate teacher in the higher secondary. Now Division bench has held, my lord, that this postgraduate higher secondary graduate should, postgraduate should be read as graduate and postgraduate.
And when was this school got merged?
March it is in 2017.
Hmm.
So.
All
as per
along
the
she was
rule of-
ME.
17. So as per the rule also, my lord, after merger, his seniority will be below me. Even otherwise, his seniority is applicable.
No. You are now addressing the issue of qualifications.
Qualification.
Seniority will come later.
No,
So you are saying that,
sir.
you are saying that after merge, that the requirement is 17 years in a high school.
High school and high or higher secondary. So
So
he is not
he's a person who had experience in ME school.
any
And when did the merger take place?
merger 2017.
2017. So according to you, this experience.
He doesn't have.
Okay. Now, what is a multi-purpose school?
Multi-purpose school belong is equivalent to my lord the high school level. Various streams are taught there.
What streams?
The technical and other. But it is not defined. I've checked up a lot. It is not.
Yeah, who's for the government? What is a multi-purpose school?
Those people were extra curricular activities also things here. There is no here to find that.
It is not defined, therefore we asked you. Yes, madam. 17 years in the high school.
Or had.
School, higher secondary school, presently is teaching in higher secondary school.
With effect from 17,
Different from presently for 5-6 years, we my lord.
but 17 years in a high school.
My lord, not for the regular principal. So my lord.
The requirement will apply. Requirement will apply. If unless you interpret that the requirement in an ME school is also to be counted.
But English school is mild with higher secondary school, my lord,
When?
2017.
So from
Normally,
2017 onwards, 2017 onwards you'll get. But then
First
that's,
read them after it.
6.
8 or 6. Government advocate plus 7. But whatever it is, my lord, they have miles the school.
when 2000,
Since 2017,
yes,
he is my lord teaching in higher secondary school also. He will be decided at present. He is the
with
teacher.
effect from how many years of experience?
Experience is not my lord, 17 years of experience.
How? In a high school, in a high school.
This might not mention because they have worked in high school, so they have approached this court. My lord, so the division bench has verified, my lord, it will be violation of articles 14 and 16. If my lord, here is also it's a Gazette Pisar, it's not disputed in the Gazette Pisar. So that will also be discriminatory, my lord. It is not qualified.
No, that argument,
Means they have become together.
you are relying on a division bench judgment.
Yes, my lord.
Division bench judgment has clarified that instead of higher secondary, it should be high school or madrasa.
Or others.
Now, whether high school will also include ME is your argument.
That I am about.
That you'll have to argue. You argue this matter. You interpret that, yes, what the intention is.
Time, my lord, I have to take instruction from the client, because in other English,
My lord,
other English
this
school.
issue was raised and this honorable court was trying to dismiss it. Let me obtain instruction. In fact, and for that, the answer.
It is of different.
No, sorry.
This was hard,
All this.
and this question was raised,
Hmm.
that you were eligible.
Ask
The
my
ten
order.
in order to pass, in order to let me apply,
No,
whether you want to withdraw,
dismissal order.
whether you want to withdraw. or not.
Tell me, while you are making this submission, that my case was going to be dismissed.
No. Hey,
Nobody has expressed.
my learned friend wanted to obtain this. whether
Madam, you get your instructions and
Yes,
see,
ma'am. I
see.
should give instruction.
Yes,
Other English school also.
heard learned counsel for parties. The disputes between the parties are with regard to the claim for being appointed as in charge headmaster of which school?
Higher secondary school.
Budon Higher Secondary School. Stop. The petitioner claims that her case for being considered as the in charge headmaster of the said school was overlooked, notwithstanding that she has the required qualification and also that she was senior to the petitioners, to the respondent. Stop. Learned counsel representing the private respondent on the other hand claims that the petitioner does not qualify for the same post in view of the requirement under Rule 12 of what rules? Assam Secondary Education, Provincialization of Services Rules, 2003. Stop. During the course of the argument, reference was made to a judgment rendered by division bench of this court in Khogendro Das and others, reported in 2019 1 GLT 583. By the same judgment, the rule 12(2)(3) Roman 3 was interpreted to include experience of 17 years as a teacher in high school, high madrasa, higher secondary. Stop. Learned counsel for the petitioner, relying on the judgment, has submitted that this interpretation should be extended for including the services of the petitioner who had rendered her initial services in an ME school. Stop. It is not in dispute that the ME school got merged with the high school, high secondary school in the year 2017. Stop. Therefore, the question which arises is whether the petitioner's service as a teacher in an ME school prior to the merger in 2017 can be considered or considered as being considered to be eligible in terms of Rule 12(2) of the same rules. MS so learned counsel for the petitioner prays for some time to obtain further instructions in the matter. Matter therefore stands adjourned and for 1 week.
Next.
We adjourn for 1 week. List after 1 week. Mr. Roy appears for private respondent. Mr. Sarma appears for the. We can dispose it of today if you. We could have disposed it of list on 30. List on 31st. 31st. 31st August.
Thursday.
Please step to item 32.
No, first let us find out what is the status, what has happened.
Lordship, we have filed the affidavit, Lordship. Finance department has already given the authority to the administrative department to clear all areas. In our affidavit, we have attached the memorandum also.
What has happened to the administrative department? Mr. Sharma, what is your stand? That they have already submitted.
Why not, they have, file their series of this, so let's see, that was matter of delay, man. That is, I have, that's why in our high court also. Here is the incident that. Since the state has not filed any evidence including judgment and order, we are not inclined to examine the issue in view of the vendor. However, the risk petitioner have got no right to recover the area beyond 3 years from the date of filing the original list. But we have come before the Honorable Court in 2004 for the first time. This is not the first time that we have been.
What was the earlier direction given?
The earlier direction was to release the area and the current surrender. Current surrender.
Then why have you come for the second time? If there is a direction, why do you want another direction?
Because there was a direction, but they made the area current surrender, but the area surrender was not there. I don't have the order, but it takes up page 45. Yes, it takes up 45 of the receipt. This is a letter from the inspector of schools to the director of secondary school. It must take up the fourth paragraph. In the meantime, the above category of teachers for not getting their salary, since the two separate institutions in the Honorable Body High Court WPC so and another WPC so in Mumbai. This is the traditional.
And what is your prayer here?
To release the area salary.
Then you already have directions.
Because as you have filed contempt petition, but then I don't have the instructions whether contempt was filed or not.
No, that instruction you may not have, but is the court required to give you repeated orders? You already have 2 orders.
One order.
All right, 1 order. Why do you want another order?
But it was passed in 2005.
Whatever. An order passed in 2005, does it get dissolved with the flux of time? Then mainly because some time is elapsed, does it entitle you to come before the court and file another petition seeking the same relief which has been granted to you earlier?
Because that is not actually clear. I don't have the petition copy of the.
We close this petition.
With the direction from them to comply pay the area salary.
That direction we can't give unless you tell us what happened after 2005. Why have you come again?
In that case, last me some time. I will have the instruction.
There is a statement in the affidavit in the director where it says that you have you have given an undertaking that you will not make an arrear claim.
We had given an undertaking, but
Then
these are stand that undertaking was there was no equal bargaining power. Because we were regularized on a condition that we have to give an undertaking. So we have to give it because otherwise we won't get our current salary. So that was not an equal bargaining power. I have got judgment to the effect. So and now when the initial cabinet decision was taken, the decision was taken that area salary is 2 After that, suddenly when our regulation orders are issued, this clause is put in that we have to.
you are claiming arrear salary of
Area salary as extension from
which year?
95 to 2005.
I think there's judgment of the Tripura bench. Your division bench in Tripura.
Because there are judgments written by Chopra by a problem here. Saying that when the employers work, the earlier salary have to be paid. Then in case the appointments are illegal, it is not a case of illegal appointments.
This is the case of area salary
I have also got two judgments once, in fact,
of,
of the division bench of the Sonora.
then the matter requires to be referred to the Chief Justice for reconsideration. No, not maybe, it is for you to submit.
That is after what should go, but I can submit those two judgments.
What is the judgment?
The first is 2007, 2 GLR 56, I have given the list of books.
Then,
Takes up the judgment.
it is not, this is not the way you argue. You go through the judgments, you point out which judgment will prevail. If you think there is a conflict, you have to raise this issue.
That was different, I don't have question.
You have to go through this judgment, it's a later judgment.
Sometime I can delete that.
The learned counsel for the petitioner gives some time to peruse the judgments and place it before the courts. At least after a week.
Yeah, take it.
Give a date after a week. 30 August. You go through the judgments.
I guess 33 to 36.
It's to be similar, GFDP. Takes care of.
Yes, request of learned counsels for the parties matter we taken up on after a week. After a week, 2013 matter. But this, you are appearing for respondents. You are for the inspectors.
That's number 8, 18, 20 and 21.
You are working as what?
Inspectors who now deputy turn their.
And you are challenging their appointment on the basis of the judgment of the court.
No, in this case, this is not on this is definite matter, on the basis of their, take document, they have the permit for their appointment, for the case. Records of the APSC will be required for
Who is for the APSC? You are for the APSC. What do you say?
And the place instruction management, also allow me, I'm to make the record full record.
Mr. Sharma, learned counsel hearing for the APSC submits that the records pertaining to the selection made for the year 11-12 will be required to be introduced before the court in order to substantiate their contentions. A praise for 2 weeks time. Yes, but your other petitions are based only on the direction of the court.
Arts is usually in DLPG as well as expenditure. And some not any the other instruction. Thereafter, they some litigation is going on, thereafter division bench pass an order. On the basis of that, affidavit filed by the respondent, the division bench pass an order. Thereafter, we file the.
All right. List after 2 weeks. Give a date.
12 September.
This should be in the part 2 list. Top of the list.
They are in the part two list. Nowadays, from part two list,
Ah.
it is given in the part.
All right. Then give a date, 12 September,
of September.
12th of September. Yes,
Item 37.
slower for the day.
38.
Pass over. Yes, tell us.
I am agreeing on the bidding side.
Ah,
That is what is divided, yeah, it's not going to be, it's gonna be space to give me, it's about maybe based upon this, fire fees or interest to.
it is submitted by the learned council, Mr. So and so, appearing for the petitioner, that the petitioner is not in interested in pursuing the matter any further, and therefore the same may be closed. Stop the however praise liberty. In the event any cause of action still survives. Mr. Ahmed appears for what university? Accordingly, the petition stands closed, interim order is vacated. Liberty, however, is granted to the petition. Yes,
Item 40.
passed over.
Forty-one.
None appears, passed over.
42.
Forty. 40. We've already done it.
42.
40 passed over for the day. He said passed over for the day.
Item 42.
Passed over for the day.